contract law, Contract Law 101. What do you need to know? So let's start by talking about what the definition of a contract is. There are three basic criteria to making a contract. The first is that there's an offer, a proposal that's made. For example, will I do or pay something if you do or don't do something? So I'm going to pay you to, leave town and go to California or wherever. Or I'm going to pay you to paint my house, or any other type of thing. And typically it is a payment that one side is making for another side to do something. And then acceptance. So I've made an offer. Now you've accepted it. You've said, okay, let's that sounds fine. Let's do that. And that acceptance can be simply saying, okay, let's go forward. It can be a handwritten acceptance. It can be a handshake. So if you imagine that you're buying a house, let's say, for example, you present an offer a written offer on the house. The other party signs and accepts that offer, or they can, of course, come back and make a separate offer. And then you have a choice to accept that or not. And the third part of it is consideration. And that's often money. So that's in consideration for X, I'm going to do Y. Something is exchanged between the parties. It's often money for products or services, but it doesn't have to be. So now a bargain's been struck. And so what does that entail? Well, there's two or more parties, otherwise it can't be a contract. It does not have to be fair. So that's important for you to understand. A contract doesn't have to be fair. It can be very unilateral, very one-sided. Negotiations are not required. Parties do not have to have even read the contract for it to be binding. People sign things all the time. For example, you buy an airline ticket. I use this example below. You buy an airline ticket. Did you know that there's a contract that stands behind that are the terms of that ticket, that they are going to, you've paid for something, and the airline is going to, in return, fly you to wherever it is that you paid them to take you on that flight. But there's a contract behind it. They can change the flight, they can change the time, they can cancel the flight, the flight can be delayed, all kinds of things. They can change the aircraft. There's all kinds of things that they can do that's behind that airline ticket purchase. So parties don't have to have read the contract for it to be binding. Negotiations aren't required. Most contracts don't have to be in writing. Certain ones do, usually relating to real estate. And the contract doesn't even have to be signed. For example, when you go on the internet and you click OK or accept to an end user license agreement known as a EULA, that's deemed to be your acceptance of it, and therefore you don't need to actually have signed it. So what are the key components to a contract? Well, I like to think of it as the who, what, when, where, and how kind of thought process. So who? Well, the first part of the contract is going to define that. Who are the parties to this contract? And what are the rights and obligations of each of the parties? What are expectations of the parties? And who is supposed to do what? Those are generally the body of the contract is going to define that. It's going to be the terms of the contract. Who's going to go out and fulfill, let's say you're trying to have a contractor come in and paint your house. So the what would be, for example, the paint that's going to be used, the timing for compliance here, which will be under the when, but the price that's going to be paid for it and so forth. Where will the contract be performed, and is that relevant? And if it matters, it should be in the contract. So for example, in the painting example, obviously the where would be at your house. When must the contract be performed? Is there a specific time period, or is this an ongoing contract? So in my painting example, it's a very specific time frame. You're contracting with the painter, and you're expecting it to be done, a month later, or 6 weeks later, or a week later. So that's part of the contract. That's part of the bargain that you're striking with that painter, that you want it done in a certain time frame. And how long will it take? And is that contract renewable? Obviously, in the painting example, probably not, but in other examples of other types of contracts, it may be. There may be a contract that your business has to find a supplier that's going to meet your requirements, and that might be a one-year contract that's renewable. And does it renew automatically? Or are there conditions to the renewal? Are there specific deadlines or milestones for any deliverables? For example, if you're contracting to have somebody draft or prepare a contract for you, or prepare that's a bad example, I suppose, but prepare a book for you, write a book. What are the deadlines or milestones for deliverables? Is there a time frame by which you expect to get the first thing? Or even more readily available example, a website. You're having a website designed for your business. What are the deliverables and payments usually are tied to that, by the way. So are you going to expect to get, the first stage of a wireframes, let's say, for the website, and then the next stage would be content, and the third stage might be the design and coloring of it, and so forth, and then the fourth stage might be when it goes live. And you might want to tie the payments to that. So that's very important that be specified in the contract for the deliverables. And why? What is the general goal of this contract? What are the parties trying to accomplish? That's really important when you're drafting a contract, to understand what it is that's the goal of the parties behind this contract. How? What's the method to perform under the contract if it's important to the parties, and how much is paid and when? So again, when we're talking about the website, the payments would be tied to those milestones or deliverables. When you're talking about my painting example, to paint, you might have a deposit up front, but then you might have a payment when maybe the downstairs is painted, and then the final payment when the full painting job is done. Very important in a contract is, what if something goes wrong? What happens on the breach of the contract? What are your rights? If one party defaults, do you have a right to sue? Must you go to arbitration or mediation? How is this contract terminated if there's a problem? What kind of notice is required and opportunity is given to the party that is in default to cure that default? And what are the remedies available on default? So to be a contract, the critical point is you have offer, acceptance, consideration, but there must be a meeting of the minds. So if there's not a meeting of the minds, there is no contract. Parties must both have intended to enter into this contract. It's important to realize that this is really a business transaction, and it has specific goals, and there are specific intentions that the parties have, and that the goal of this agreement or contract is to memorialize in writing those goals and intentions. The parties must have a clear sense of what those goals are that they want to accomplish, because otherwise, how can you memorialize that? If you are reviewing the contract, if you're not the party who's drafting the contract, then you need to negotiate that contract so that it is an even contract, so that your goals and needs are also met. Very important that you do that, because every contract's negotiable, just about. So what are some typical terms? Well, some of the typical terms are, again, just to go back over what we discussed a little bit earlier, is who are the parties? When does the contract commence and when does it end? What's the actual time frame of the contract? How is it renewed if it is renewable? What are the various requirements or obligations of each of the parties? What is the timeline required for each of those obligations? What constitutes a default by a party? What have they done that could trigger that default? And then if they have defaulted, what kind of notice are you required to give that defaulting party? And what opportunity do they have to then cure that default? And then when there is a breach, what rights does the non-breaching party have? And what state's laws are going to govern the contract? This is just a bare bones outline of some of the very important kinds of things that need to be covered in a contract. So in conclusion, you need to read the fine print. That's really important. Contracts are important legal and business documents. And it's really important that you understand that. Contracts can be critical to the success or failure of a business. They should be drafted carefully by experienced business attorneys, and they should be reviewed and negotiated if you're not the drafting side of the deal by experienced business attorneys. So if you have questions, please call me. I'm Nancy LANARD, 215-392-0030, extension 101. We are here to help, and I look forward to that opportunity. Here's all my contact information. I look forward to the opportunity to hear from you. If you have questions, you have any comments, you'd like to see another video, please feel free to email me or call me. I would look forward to that opportunity to hear from you. And it's been a pleasure, and I look forward to hearing from you and to helping you with your contracts as you move forward in the business world.